I think it's still morning. Docket 2018P. Oops, sorry, that was the last one. 2018P0350. Dantuluri, am I saying that correctly?
Yes.
Versus Dantuluri.
Good morning. May it please the Court. My name is David Hadass. I represent Madhuri Dantuluri, the mother in this child custody dispute. The mother, the record is very clear on this. The mother was the primary caretaker of these children during their entire lives. She was very closely bonded with these children. And going forward, she was in the best position to care for the children, given her work schedule compared to the father's very busy work schedule with frequent travel. Nevertheless, these three...
I thought the record indicated there'd been a change in the father's work schedule and that the travel wasn't as... that wasn't a live issue anymore, no?
I believe his testimony was that he hoped to be traveling less in the future.
Didn't the judge make a different finding?
The judge may have. I think the record is that he still works full time at a very demanding job. While in the past traveled frequently, was hopeful that that would be less in the future. I think that's essentially what his testimony was.
Okay.
Those three factors, who was the primary caretaker of the children, who's closely bonded with the children, who's in the best position going forward to care for the children, those are among the most predominantly cited factors in the case law. And despite that, in the judge's 76-page decision, does not mention one of those factors even once. Instead, the judge focused almost exclusively on the mother's behavior, her lack of cooperation, to use the judge's term, during the divorce proceedings. Specifically, that there were difficulties between the mother and the court-appointed GAL in scheduling interviews with the children, that there were difficulties.
So to the point that her son never saw the GAL, is that right?
The son never saw the GAL. That's correct. And
also never met with the father and the therapist, right?
That is correct. And I would place some of the blame, or a good part of the blame, on the father. He's a parent too. What comes clear through the record is...
Go ahead. I was just going to say, it's not a matter of blame, and it's not a matter of where we place it. It's our review of what the trial judge finds. And while I appreciate that there are a lot of factual issues in the case which your client no doubt believes were improperly decided adversely to her, we have to accept those factual findings unless they're clearly erroneous and unsupported by the record.
We certainly agree with that, and our primary argument in this case is that the judge relied on improper factors. So putting aside whether there's evidence in the record to support those facts that the judge found.
So what do you say are the improper factors?
As I said, the judge relied almost exclusively on the mother's behavior during the divorce proceedings, the inability or unwillingness to schedule appointments and things of that nature,
resulting in one, her unwillingness to meet with the therapist so there could be any kind of assessment, and completely depriving any professional of access to her son. And even the meeting with the two younger children, she was late, and there was only a part of it done, and it was never scheduled for a meeting with their father, right?
Guilty as charged, but here's the main point.
Doesn't that leave the judge with, and help me with this, with a sense that huge pieces of information that would be useful to know if you were making this extraordinarily important decision, you didn't have because she wouldn't let you have them?
Well, I would direct your attention, Your Honor, to the GAL's report. It's a full, robust report. She met with both parents. She met with both of the minor children. The son, not quite as relevant. He is over 18.
Well, it was when he was 15.
By the time of trial, he was over 18, and it would actually have been to the mother's benefit from a litigation perspective if the GAL had interviewed the son. The son was very closely bonded with the mother and was completely estranged from the father. I would also direct your attention to the emails that the GAL appended to her report. They do not read like someone who's obstructing her investigation. There's a lot of difficulties in scheduling, and it goes back, and it's somewhat of a two-way street, I would suggest. But the main point is that when it comes to child custody decisions, these are not the factors that courts look at. Is there some blame for the mother? Sure. But she can be punished. The court is fully capable of holding her in contempt. The court is fully capable of applying appropriate remedies. But one of those remedies is not child custody. You don't use child custody to punish someone who you perceive to be uncooperative in the litigation process. What you do look at, and the cases are clear on this, especially a case from this court, Al-Shar, that lays out what the court terms certain constants: bonding, primary caretaking, all of the factors that in this case clearly favored mother.
You would concede, I assume, nonetheless, that to the extent that a party is found to have not followed orders of the court to provide access to information or to cooperate in examinations, etc., that can be understood by the fact finder as a negative in terms of whether that parent would be the appropriate parent to have primary or exclusive physical custody given the best interest of the child's standard controls.
Certainly a consideration, but not a consideration that comes anywhere near the top of the list. And there are several cases from this court, like Al-Shar and Haas, where one parent intentionally, willfully, deliberately violated court orders in a much more meaningful way than in this case, taking children outside the jurisdiction, depriving the other parent of their visitation rights. And the court said, yes, that's bad. Yes, this person, an appropriate remedy should be applied. But you don't use child custody as a way to punish the.
And this, I don't think there's any question about that. But the question is what the relevance of not just lack of cooperation, but lack of cooperation on those things. And then you have the medical issue as well, right, which is concerning. What effect those have on the issue of the best interest of the children, which of course is the issue, right? Is it in the best interest of the children to be raised in that situation where the contact with their father is arguably, at least deliberately frustrated, and any other attempts at assessment are frustrated as well?
Let me speak to a couple of those issues because I think the record is much more muddled than how the judge portrayed it. So, for example, on parental visitation, which I think is probably the most weighty issue that the judge cited, essentially accusing the mother of interfering or impeding the father's visitation with the children. What the record shows is that the father was very passive in asserting his rights to visit. Months would go by and he was not in contact with the mother about visiting the children. He apparently was content up until a point. At that point, he wants to have visitation. The children, as the GAL clearly lays out in her report, were very apprehensive about visiting the father. They were okay with going over there, but
apprehensive about spending the night without the way that they spent the night with their mom.
In particular, spending the night. That was the big issue. So what the mother says to the father is, you need to talk to the children. You need to convince them to come with you. Essentially, she took a hands-off approach. I'm not standing in the way, but I'm not going to be the one to force the issue. If someone's going to force,
and they were 8.
Yeah, 8, 9 in there. That's right. He's their parent too. He's their parent too. If someone is going to force the issue of them spending the night with the father needed to get involved, and he simply didn't. He just sat on his hands and then complained later to the court. The mother, even to facilitate these visits, even met the father at a police station so that a police officer could mediate essentially between the children and the father. And the police report on this one occasion is in the record, and it shows that that's exactly what happened.
But why? The police officer said, "Do you want to see your dad?" And they said they did, and so they went. It doesn't sound like you needed a police officer for that if their mom had said something mildly encouraging.
What happened was the children refused to go with the father overnight, and what the police officer mediated, and this comes through in the police report, is that, okay, how about visitation until 8 p.m.? The father agreed. At that point, the children went with him. So the onus should not be exclusively on the mother to, quote unquote, make this happen. That's what the GAL criticized her for. She didn't make this happen. Some responsibility must be placed on the father to make it happen. But as we concede, this could have been handled better. The main point is, just because things weren't handled perfectly or even well, that's not a reason to take away the children from the mother. And what we're left with is, frankly, an appalling circumstance that the mother is at home in Bellingham, ready, willing, and able to care for the children. The children are in the father's apartment across town, not with the father, but with the paternal grandparents, who the children had no relationship with prior, and who don't even speak English. So it's not so much who's going to care for the children, the mother or the father. It's who's going to care for the children, the mother or the paternal grandparents. And there was no evidence in the record that the mother was in any way an inadequate parent. In fact, by all accounts, the children are thriving, and largely due to the mother's
there were
raising
some
them.
other concerning judgment issues, right?
So there are a number of judgment issues that the court pointed to, really more that speak more to the legal custody, the ability to make judgments about medical care and education and things of that sort.
Just hand feeding them so that they became unwilling to eat on their own at school, arguably. I don't think that is supported by the record. What is supported is that they were underweight. They were both born with certain challenges, and the mother, who very clearly is a doting mother, would come to school to make sure that they ate their lunch. And it's really the decisions that the mother has made over the course of these girls' lifetimes that the judge criticized and that the judge relied upon to deprive her of legal custody going forward
are rather mundane.
Well, not the heart surgery so much.
Well, with respect to the heart surgery, I would encourage Your Honors to look at the doctor's reports, the surgeon's reports, even up until August 2012, which don't raise any alarms, don't say anything like this is an urgent situation or this is an emergency. In fact, the most recent physician's report says if the parents had very good questions, good concerns, if they don't want to go forward with the surgery right now, I'd like to see her in a year. Okay? So then 3 or 4 months after that, December 2012, that's when the father really first changes his mind and goes on the record saying, I really think we should go forward with this. And the mother immediately acquiesces and signs a stipulation saying, yes, you can go ahead and schedule this surgery. So the difference between the mother and the father on the heart surgery is not so great.
All right. We're going to have to leave it at that.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Lauren Klein. I represent Mr. Dantuluri. I just want to begin by saying I think Justice Sullivan put her finger right on the crux of the matter, which is that Mother here would like to reinterpret the evidence that was adduced at trial in a more favorable light, but that is not her prerogative. Your job, as you well know, is to review the evidence. It's not to review the evidence, but to review the decisions made by the trial court, only to determine whether there was evidence in the record to fully support it, or even to support it by the standard of that there wasn't an abuse of discretion, meaning that the judgments have support in the record and don't fall way outside the realm of what would be an appropriate decision based upon that record. I disagree with my brother about the various points in the record that he points to, particularly that the mother was cooperative and that the father's laxity or passiveness is what caused problems. Father may have been uneager to fight with his then wife, but he certainly wasn't in agreement, and he asserted himself throughout. And the GAL and the court both found repeatedly that the decisions that the mother was making were problematic. They were concerning. For the mother now on appeal to argue that her decisions were ordinary or legitimate or unremarkable is completely beside the point. The court and the GAL, or the court based upon the GAL's report and the taking of evidence over 8 trial days, she found that the judgments of the mother were questionable and concerning, and on one occasion alarming.
Is it fair to say that although your brother argues that the judge abused her discretion in making the determinations that she did, that there isn't an argument, maybe I overlooked it, that specific findings were clearly erroneous?
There is no argument that specific findings were clearly erroneous, not one. There's nothing in the appellant's brief that points to a single finding that was outside the realm of what could be supported by the record, not one. And the one argument, the one other, all of the arguments in my view fall within simply they would prefer that the weight of the evidence had been found differently, and that's just not what's at issue here. I'm sorry. Go ahead.
Judge Agnes, was your question answered?
Yes.
Okay.
Thank you.
Is there anything in the record that reflects why the GAL changed her recommendation? And what are we to make of the fact that the written report says one thing and the testimony another?
I think during that, if I'm not mistaken, I think during the lapse of time between the written GAL report and the trial where she testified, there were attempts to have the mother evaluated by the psychologist, and she put up every roadblock she could think of. One by one, as the roadblocks were cured for her, she came up with new ones. First it was that her insurance wouldn't pay for it, or she couldn't afford it, so that the court asked the doctor to make payments payable over time. She said that was no good. Eventually the husband said he would pay for it. She still wouldn't come. And by the way, Your Honor's brought this up during my brother's argument, but it is a fact that not only was the mother uncooperative about the older son meeting with the GAL or with a psychologist, but she absolutely refused to ever allow the twin girls to meet with the GAL, with the father. So the GAL never got the opportunity to see the father interacting. So for all my brother says about how their relationship wasn't substantial enough to support custody, nobody who was in a position to make rulings ever got a chance to see. In fact, he was a very involved father. There was plenty of evidence in the record to support
but his
those
argument
findings.
is even if she deliberately frustrated and as frustrating as it reads, it's still the best interest of the children, and they were very bonded to her.
And I have two responses. The best interests of the children was the very standard used by the GAL and by the court, insofar as these judgment calls on mother's part went to the very heart of what kind of relationship she was going to allow the father to have with these girls. And she was making it very clear. She said it out loud, she believed it was unimportant for them to have a relationship with their father, and that it was up to him if he wanted to convince them to have a relationship, but she wasn't going to foster it. Well, that alone gave grounds to award him custody, because the court decided, as it was well within her right to do, that it was important for these girls to have relationships with both. As to your second part of your question about being bonded, the court and the GAL in this case found that the evidence that mother put in as to their bonding was actually evidence of her self-serving interest in the girls being dependent on her. It wasn't seen as a positive thing that she slept in the bed with them and that they wouldn't sleep at Dad's house because they were only accustomed to sleeping next to Mom's body. Again, the fact that she went to school and hand-fed 8-year-old girls, she can call that bonding. But the court didn't. The court said that is conduct designed to make mothers' position so central in the children's lives that they are completely dependent on her and not acting age-appropriate. So all of these things that the mother says are, or mother's attorney says are, the traditional things relied upon, it's not that they were overlooked. It's that the court found the evidence supported the contrary conclusion, which was they would be better off with the father. As it happens, and this is just for the record and not so much part of your decision-making, but the girls have been, for the last couple of years now, while this appeal's been pending, essentially living with father primarily. They are thriving. They're doing great. So, and you're right, Justice Hanlon, to say that in the record it was made clear that by the time of trial, father's travel schedule had been cut way, way back. So travel was no longer an issue. It may have been early on in the record that it was a hope that he would bring it down, but by the time of the judgment, it had been. This trial was on 8 separate days over about, I think, 9 or 10 months. So, are there any other questions? I would just add that the one remaining argument made by mother is a legal argument based on preclusion, and it's just wrong. That's not how preclusion works. There was
about the contempt.
I'm sorry?
About the contempt.
About the contempt, right. The standard is an entirely different standard, and the fact that mother was not held in contempt in no way precluded the court from using the evidence that was the factual basis for the contempt to make custody determination. That was an incident that involved very inappropriate conduct on the part of the mother, where the children were actually asleep at the father's apartment, and she refused to accept that they were having an overnight, called Dad a liar, and sent her older son over there to pull the kids out of bed, wake them up at 11 o'clock at night. So the court was very impressed in a negative way by this incident, and the fact that she didn't hold mother in contempt has no bearing on her ability to use that incident and allow it to affect her judgment. The fact of the matter is she, in not finding the mother in contempt, wrote a line that required the court cannot find by clear and convincing evidence that mothers willfully disregarded the court order for parenting time. However, the court said, the mothers shall support the children having their overnight parenting with father, including providing them with clothing for overnight. I mean, that's a specific fact, but it shows that the court meant business, that the court disapproved of what the mother was doing, whether or not she was finding them in contempt. One other thing, the Haas case that my brother mentioned, it's entirely distinguishable. It is a case where the mother took the child out of the jurisdiction on 2 occasions, but it didn't go to the heart of who was a better custodian for the children. It was maybe bad judgment to do it without father's permission, but it was on 2 individual occasions, and then they came right back. It wasn't the kind of pattern of parenting, of intrusion in the relationship between the children and the father that this mother perpetrated and continues to perpetrate even now. It's important to recognize that the court noted the GAL's comment that it wasn't even worthwhile to hire a parenting coordinator because the mother wasn't going to comply with whatever the coordinator told her to do. That's the kind of obstructionist attitude that, long-term would cause harm to the relationship between the father and the children. And if I could have one more moment just to point out that with regard...
4 minutes and 37 seconds.
Okay, thank you. With regard to the mother's poor judgments about education and medical decisions, at the point when she was resisting the surgery, to me, of all the things in the record that jumped out, personally, it was that the mother wanted to put her own opinion ahead of the opinions of 3 experts in heart surgery based upon her own decision, her own conclusion that the atrial deviation, I'm not a doctor, but something like ASD, was going to close on its own, the way that her other daughters had. And when she was asked at trial, what did she base this medical conclusion on? She said, her science class in high school.
College.
I thought it was high school.
I thought it was I could be wrong.
Okay, I'm not
the
sure.
record will speak
Either way, I would say that's pretty striking. Another poor judgment, she wouldn't allow the twins to be in separate classrooms in preschool. The principal finally had to say to her, you have to pull your kids out of this school if you won't put them in separate classrooms. They aren't interacting with other children in an age-appropriate way. They're only talking to each other. So either you allow them to be separated or they have to leave the school. That's when she relented. It seems like the record supports that was the kind of intransigence she displayed over and over, that it wasn't until something big happened that forced her hand. Like father finally saying, 4 or 5 years have gone by that the doctors have been saying this child needs open heart surgery and you have been standing in its way, and I can't stand by and watch my child suffer harm because of it. So he went to court. He filed papers. And yes, she then signed a stipulation, but it took for him to do that for her to agree to let the surgery go forward. Needless to say, the surgery went forward and the girl's doing great.
Was it 2 surgeries? Was it a patent ductus and something else, or was it just the one?
It was, I didn't hear the word.
Was it 1 or 2 surgeries? Was it a patent ductus and something else, or was the other child the patent ductus?
I don't even know that word, so it must not have been this one. I know there was the catheterization, and then there was the repair of the ASD.
Okay.
I think the bottom line, all that I really have to say is that all of this emphasis on punishing the mother, there's simply no evidence in a very, very lengthy record that this had anything to do with punishing her as much as it had to do with how the misconduct of the parent adversely affected the welfare of the child, as in the Murphy v. Murphy case, and that is the standard that was used, and it was always the paramount consideration. Thank you, Your Honors, for your time.
We'll take the matter under advisement.